Hello there, my name is Terry Gorry. I'm a solicitor and I am a former education executive with the CPSMA, that's the Catholic Primary Schools Management Association. I've just made this short video for you in relation to family law issues for schools and the sort of common problems which arise in relation to the breakdown of relationships between parents and the consequent problems then or issues that sometimes arise for schools. So what are the responsibilities of schools where relationships break down? Firstly, there are three key concepts to understand in this area. The first is guardianship. This is the most important one from a school's perspective, because the right to information to a parent will flow from the concept of guardianship. In other words, who is the guardian? Access and custody are also concepts that you might just understand in a broad global sort of a way. Guardianship basically means the rights and duties of parents in respect of the upbringing of their children. A guardian has the right to make all major decisions, that is, global decisions. So if you think about guardianship, think about global issues that affect the child's upbringing, and this includes education. This is where schools come into the equation. Also includes medical treatment, religious matters, health requirements, general lifestyle and development, and decisions about leaving the country. Access then is the right to see and communicate with the child, and custody is the right of a parent to exercise day-to-day care and control, physical control of the child. So who can be a guardian? Because this is the important question for schools. The natural mother is automatically a guardian of the child. Whether the father is a guardian or not will depend on his relationship with the mother. If the two people are married, he is automatically a guardian. If they're not married, he's not a guardian. It's as simple as that. However, he can become a guardian. So an unmarried father, a father in a relationship with a mother who has a pupil in the school, he can become a guardian in one of two ways. He can apply to court for a court order appointing him a guardian of the child, or both parents, the mother and father, can swear a statutory declaration. They both sign it and he then becomes a guardian. So once he's a guardian, then he's entitled to the same information in relation to the child's education and development and progress and so on as the mother. So, married, separated, divorced or unmarried, these are all the various situations that you may come across, but it's quite straightforward and simple. Married parents, both parents then, mum and dad, are both guardians and they're both entitled to information from the school. If they're separated, they were married but they're separated, then both parents are still guardians and they're both entitled to information from the school. If they're divorced, even though they're divorced, both parents in Ireland are still guardians and entitled to information from the schools. So the unmarried situation is the only one that really should cause an issue for schools. Only the mother is entitled to information because she's automatically a guardian in Ireland in an unmarried situation, unless the father has become a guardian by court order or statutory declaration, as I've pointed out in the previous slide there. What information is a guardian entitled to? Well, essentially all information emanating from the school. For example, about the child, obviously. For example, school reports, parent-teacher meetings, notifications, and any other meetings to do with the child's education and or welfare, including religion. If there are disputes between parents, and there regularly are, unfortunately, the school would be well advised to firstly seek a solicitor's letter from one or both parents clarifying the position. In other words, which of them is a guardian or are both of them guardians, because this will essentially determine who gets the information from the school and who needs to be communicated with. The school would be well advised, however, to consult a solicitor for advice in this area, because the parent or any parent can furnish a court order from a family law court which purports to set out the current position in relation to the child. However, The school won't know whether this order reflects the latest position between the parties or not. And family law disputes typically can be bitter and protracted and can involve many trips to court for various orders, variation of orders, challenges to orders, and so on. So the school would be in a difficult position there because they may not have the most current position, and a parent may give you a selective order, in other words, the one that he or she feels best serves their purpose. A recent Equality Tribunal decision in Ireland was an interesting one. It was a finding against a school for discriminating against an unmarried father because the school failed to furnish him with the same information from the school as the mother. The father in this instance was a guardian, even though he was unmarried. This was a costly mistake because the Equality Tribunal awarded the father monetary compensation against the school. I think the sum was around about €20,000. I'm not 100%, but it was certainly in the thousands. You can contact me, Terry Gorry, solicitor, through any of the websites that you see on the screen there, or through my email address, terry@educationlawireland.com, or you can contact me on either of the numbers that you see on the screen. Thanks for watching, and I hope you found this video helpful.